So welcome back to the daily answer writing initiative at 9 p.m. I am Mohana Priya from Officers IAS Academy. So let us start the discussion for the day 4 question, and then by the end of this video I will be giving you the question for the day 5. Okay, so the question for the day 4 was: the sedition laws have long been a subject of debate in democratic societies, with concerns over their potential to stifle dissent and freedom of expression. Critically analyze the relevance of sedition in democratic India. Before we start with the discussion of this question, let us quickly have an overview about this sedition law in India. So first of all, what is sedition? So sedition is defined in IPC section 124A, that is Indian Penal Code section 124A. What is the definition of sedition? Any person who by words. The words can either be spoken or it can be in written form. Yes, or it can be any sign or visual representation or through any other means or otherwise. If such actions is going to create or attempts or even attempts to create a sense of hatred or disaffection, or contempt against the government, it is called as sedition. So this has been the definition of sedition, which is given in IPC section 124A. Now, when did this sedition originate in India? So this sedition law has its colonial legacy. It originated way back in 1870. It was brought in by a person called Thomas Macaulay. So this was initially brought in by the British in India to curb the national movements. However, India decided to retain this sedition law even after independence. This sedition has continued to be right from the independence. It has been a topic of controversy for so many reasons. So this particular question is being given because sedition has been in news for some reasons. Last year, the Supreme Court decided to put a hold to this sedition law until a government forum re-examines its validity. And it was in news recently because the Supreme Court has referred the constitutional validity of the sedition law, the petitions which claim the constitutional validity of a sedition law, to a 5-member constitutional bench. Now let us come back to this question. So the sedition law has been a subject of debate in democratic societies. Yes, it has been a subject of debate due to so many reasons. There's been so many concerns surrounding the sedition law, because of which it has been in debate. As you can see, the definition which we saw just now, it shows that any action which creates or even attempts to create a sense of hatred, disaffection or contempt. This particular definition seems to be very vague, isn't it? It has a very vague definition, because of it the chances of misusing it are very, very high. It is a very subjective definition which can be interpreted by any person in any way, because of which there are high chances of it getting misused. And not only chances, it was being misused in so many circumstances. There were so many activists, so many journalists who were critical of the government were arrested on charges of sedition. It seemed to pose a threat to the basic freedom of speech and expression, because of which it was, of course, a topic of debate in the democratic societies. Whether do we need to continue this sedition law in India? So this particular question is asking us to critically analyze the relevance of sedition in democratic India. So the meaning of the term critically analyze is you need to, of course, address both the sides of the sedition law. We need to address the side where it has concerns, concerns in the democratic society where sedition law is not needed in India, whereas you will also have to address a side where you will have to write down points which says that sedition law continues to be important in India. So let us see how to structure this answer. Yes. So we will start with a basic definition of the sedition as the introduction. So you can start by giving the basic definition of introduction. Okay, basic definition of sedition as introduction. And then, okay, in the first part of the question says that it has been a subject of debate in the democratic societies where it has concerns over its potential to stifle dissent and freedom of speech and expression. So the first part of your answer has to address what are the concerns which are surrounding this sedition law. What has been the reasons as to why it has been criticized and called for abolition? This should be the first part of your answer because that is how the question begins. So what are the different reasons as to why this sedition law has been criticized? First, we have the concept of misuse and abuse because it is being used as a tool to silence dissent. So many journalists, activists, as I've told you, have been arrested on charges of sedition just because they have dissented against the government. And of course, the second point is the vagueness and ambiguity. In the definition, we saw that there were words like hatred, disaffection, right? These are the words which are very, very subjective in nature. So some speeches which I hear can instill a sense of hatred. I can consider it to be a hate speech, whereas it might not be the same for another person. So this interpretation can vary from person to person because the definition is very vague and ambiguous. And of course, it is being used as a tool to curb free speech, because of which people are now in fear even to give a very legitimate criticism against the government. So in India, we have the fundamental right which guarantees every citizen of the India to they have the right to dissent against the government. They have the right to criticize against the government. However, this sedition law is being used as a tool to curb this free speech. Even this legitimate criticism is not coming from the people. People are refraining from it because of the fear of being arrested under sedition. And the next point which we can mention is the global trends. So this colonial law, this sedition law, as we have discussed, was brought in by the British. Yes, it has a colonial legacy. However, it is important to know that the United Kingdom themselves have abolished this law way back in 2010 itself. Not only United Kingdom, there are so many countries in the world which have abolished this sedition law, or they have either abolished or restricted the sedition laws. Okay, so these are the concerns which are surrounding the sedition law, because of which it is being called for abolition. Now, since this question is asking for a critical analysis, it is important to state the reasons as to why it is considered to be essential in India, why it has to be continued in India. So this reasons as to why sedition laws have to be continued in India is not only the point of view of the citizens, like it has been quoted by the Supreme Court in the Kedar Nath Singh judgment, where it has said that the sedition law is definitely constitutionally valid and it has to be continued in India. However, it should not be used to curb criticism. This has been the Supreme Court's judgment in Kedar Nath Singh. Not only that, we have a recent Law Commission report also which has stated that sedition continues to be constitutionally valid. However, there has to be some reformations which should be brought in the definition of sedition to make its implementation much better. So let us, since this is a stand of both the Supreme Court as well as the Law Commission of India, let us see what are the reasons as to why sedition law has to continue in India. Of course, we have to retain the sedition law in order to ensure the national security. So there are lots of acts of violence, terrorism which is happening in the country in order to make this society unstable and government unstable. In order to curb and prevent such acts of violence, it's necessary to continue this sedition law. Of course, protection against insurrections. There's a group of people who are propagating false propaganda against the government by unlawful means in order to topple the government, which definitely has to be curbed. And of course, in order to curb hate speech, there's been rising cases of defamatory speeches, hate speeches, and sedition is considered to be a deterrent to curb these hate speeches which bring contempt against the government. And next, balancing rights and responsibilities. It is indeed true that the fundamental rights of India guarantees every citizen the right to freedom of speech and expression. However, it is not an absolute right. It comes with reasonable restrictions, isn't it? So this particular sedition law is considered to be a reasonable restriction on the fundamental right. And of course, for the preservation of unity. For a country with such a diverse population, in order to preserve the unity, in order to prevent the anti-social elements from disturbing this unity, it is important that we have a law which continues to stay so that the unity and integrity of India is maintained. So these are the points which you can mention. And along with this, there is another point. We have in the judicial system, we have a concept called the contempt of court. So when we have a concept called the contempt of court, it is important to have a similar provision for the contempt of government also. So that is also a point which you can add. So out of these points, you can choose 4 or 5 points so that you can stick to the word limit. It's not necessary that you have to mention all the points. Okay. So now, how can you conclude this answer? It is better to stick with what the Supreme Court and the Law Commission report has been published. Okay, instead of stating a blatant stand, we can conclude by saying that, see, it is important to understand that the intention of the sedition law is not wrong. So sedition law is of course aimed at curbing only these hate speeches against the government. The true hate speech which is intentionally targeted against the government is what the sedition law aims to curb. It is not intentionally trying to curtail the freedom of speech and expression. The problem comes only in the people who tend to misuse it. The problem comes only with the implementation of the sedition law. So sedition law as such is intentionally correct. It is intentionally aimed at only curbing the acts that lead to an incitement of violence which disturbs the peace in a society. So what can be done is, you can quote the recommendation of the 22nd Law Commission, which has given the 279th report. In that report, it has favored the continuation of sedition law. However, it has also mentioned that it is important for the definition to be more objective. The definition has to be given more clarity so that there will be no issues with this implementation and it is not misused. So you can conclude by saying this. Yes, so this will be the appropriate answer for this particular question. So of course, there are so many students who had given very good answers for this particular question. So out of which we have chosen 3 answers. So let us try to see how well they have written. So the first paper is that of Pavitra J. Okay, first of all, I would like to mention that your presentation is really nice. So very good presentation. So she, as you can see, she started with the definition of sedition. She has given the definition of sedition and then she has continued her answer. So she has now written about the relevance of sedition law in India. So the flowchart representation is very good. But as we have discussed, so Pavitra's points are all very nice. So she has written about this maintenance of unity and integrity, maintenance of stability of the state, restricts hate speech, reasonable restriction. All the points are very good. But before writing the relevance of sedition law in India, it's important to address the first part of the question, which talks about the concerns surrounding the sedition law. So your answer is right, only that you will have to change the order. So you've written the sedition law is irrelevant in democratic India, right? So instead of giving this subheading, you can just put the concerns surrounding the sedition law, the concerns which calls for the abolition of sedition law. You can just title it in that way, and rest of the points are good. Suppressing the liberty, colonial era relic, discarding Supreme Court's decision, misuse of law. The points are all good. Only the thing is that you will have to place this concern surrounding the sedition law in the first place. Okay, and the conclusion is good. So she has brought in this current affairs concept of Bharatiya Nyaya Sanhita bill, which has been introduced by the government in order to benefit the people without curtailing the rights. Okay, so this was Pavitra's paper, and then we have Yalini's paper. Yalini, okay, who belongs to the D batch, and yes, her answer was also good. So she has again started with a definition, a simple definition for sedition law. Yes, that is how you have to begin this answer. And then significance of sedition law. So all these papers, it started with this. So all the papers, you've given good points under the subheadings. You've also critically analyzed this topic. The problem is that you'll have to write the issues with the sedition law, since that is asked in the first part of the answer. So you have to start with the issues and then you can say, however, sedition law is considered to be essential in democratic India for the following reasons, and then you can quote the relevance. So this answer was also very good. The points, everything was nice, and then the conclusion was again, she has quoted the Kedarnath Singh judgment, which is fine. So this is a good way of concluding. Okay, when you're going to quote such cases in your answers, it will enhance your marks. And then the third answer was that of Kritika. Here again, your presentation was nice. So she's again started with an introduction. Yes, a 2-line introduction, which is more than sufficient. So sedition in democratic society. So you've given this subheading and you've written 2 lines in it, right? So this particular part is not needed. So it is not, you can directly start with the answer. So the sedition in democratic societies is in no way relevant to the question which is asked. So you can just skip that particular point. And then she has written about the relevance of sedition in India. Yes, so same points, the points are all good. However, you can write the challenges, the concerns surrounding the sedition law in India, and then you can write the relevance of sedition law in India. Yes, and okay, so her conclusion was a very generalistic conclusion. Try to include the Law Commission report or the Kedarnath Singh judgment, any case which is relevant to the sedition, so that your conclusion becomes even more enhanced. Now, there's another paper for which the name, I don't want to mention the name. So here, this particular paper, the answer, I would like to say why the answer should not be written in this way. So this person has started with a definition of sedition, which is fine. So that is the apt introduction. And then this particular person has written about sedition versus Article 19 Clause 1. So this particular subheading which you've written is not very apt and relevant to the question that is asked. So concerns surrounding the sedition law is the question, is the answer which is expected in the first part of the answer. You've tried to link sedition only with the curtailment of freedom of speech and expression. It is not the only concern. There are other concerns also. So this particular subheading is quite not relevant. And also the issue with this particular, in the first part of the answer, in the first page fully, the person has talked about the Kedarnath Singh judgment and what is going to be the impact in case the Kedarnath Singh's judgment is going to be implemented. So that is not the demand of the question, right? So the impact, it's going to protect citizens' rights, it's going to narrow the scope of the misuse of the sedition law, it's going to instill more responsibility. So this will be the impacts of implementation of Kedarnath Singh judgment. But why do we have to talk about the implementation, which it is not at all asked in the question? So please, so this entire part which you've written in the first page is not needed to the question at all. So your answer starts only in the second page. You've written about the irrelevance and you've written about the relevance, right? So this is where your answer starts. So whatever you've written in the first page is not needed to the question. So don't dump all the facts and knowledge that you have about a topic. Try to restrict your answer to whatever is asked, and also see 2 complete pages you've filled, and definitely your answer will have more than 250 words. Okay, so the word limit is just 150 words. Kindly please try to stick to the word limit. So it has to be within 150 words. Okay, so this is about the paper discussion which I wanted to do. And now let us come to the day 5 question. So what do you understand by the term invasive species? How do they pose a threat to the native habitats? I hope everyone will make use of this initiative to the best possible extent, and please do continue to write your answers. Guna Mathivanan sir will continue this daily answer writing initiative from day after tomorrow. Thank you so much.